Remedial Law and Criminal Law. He obtained his LLB degree in the University of the East, graduating magna cum laude. He is a lecturer in the Philippine Judicial Academy and is one of the most sought-after reviewers in the country. He is currently a reviewer in criminal law and remedial law in various review centers such as UP Diliman, UP Law Center Bar Review, UP Visayas, UP Mindanao, UST, Nueva Caceres in Bicol, Aquinas University in Legazpi, Bicol, Silliman University in Dumaguete City, and Liceo de Cagayan in Cagayan de Oro. He is also a professor in the University of Santo Tomas in criminal law and remedial law. He is currently the consultant of the City Mayor of Manila concerning legal matters. He is a member of the UP Law Center Bar Exams Expert Committee in Remedial Law and the former Dean of the University of the East of the College of Law. He specializes in the following areas: civil procedure, criminal procedure, provisional remedies, special civil actions, special proceeding, and evidence. I am indeed privileged to have the chance to introduce to you a well-respected professor and lecturer. Ladies and gentlemen, let us please give a warm welcome to Dean Carlos Ortega.
Well, thank you for this extravagant introduction. This is quite a big batch of reviewees, and I subscribe to the belief the more lawyers we have, maybe the better our society will be. I was tasked to lecture on remedial law because I found out that many think that I'll always be lecturing on criminal law. Your preparation for this subject should be different from your preparation for substantive law. Procedural law involve only rules, and the rules should be evaluated by you on how it affects the progress of a case. There are those which are only routinary, or you don't have to bother about them. But there are those which are fatal to the success of a case should you fail to comply therewith. Studying procedural law is like knowing the alphabet. You have to follow a sequence. In the alphabet, even if you know all the letters comprising the same, if you do not know the chronology in which they are encountered, you do not know the alphabet. That is procedure. So when I was invited by the dean here to lecture on the subject, I said, I have found out ever since I became a lawyer some 54 years ago. That procedure is simple. If you know the sequence, you should know how to begin, where to begin. Under our rules of court, there are rules which are not really involved in the main flow of the procedure. They are just incidents of the procedure. So you don't have to give so much attention to them. What you should know is the principal flow of the procedure. Incidents like amendments, the rule on motions, these are simply collateral to your knowledge of how the case should go. So I said, I always want to have future lawyers understand what they will encounter when they become full-fledged lawyers. This afternoon, I shall discuss with you the procedure involving civil actions. You have to isolate the subject instead of taking them at random. Instead of learning the procedure, you will get confused. And this is how I have been lecturing on this matter in the other schools where I'm handling remedial law. In the civil cases, the procedure starts with the institution of a complaint. Under our present laws, this may be under the local government code before the proper barangay, or under the rules of court in a court of law. Now that the Supreme Court is keen on resorting to alternative dispute resolutions, the obvious purpose is to arrest the flow of cases to the judicial tribunals. This mechanism for alternative dispute resolutions is now becoming important. So you should know that there are instances where the rules of court should not primarily be invoked. Under Section 412, Chapter 7, Book 1 of the Local Government Code, you have a specific provision there. No complaint, petition, action, or proceedings should be filed directly in court without the parties having a confrontation before the proper lupon. And corollary to this, Supreme Court had issued a long time ago Administrative Circular 1493 directing clerks of courts not to receive the filing of any case without the certification by the secretary of the barangay that the required conciliation or mediation had been resorted to. It does not follow, however, that before a case may be brought to court, that it should always be ventilated before the barangay. You must know when this requirement governs. Under this initial filing of a complaint, you must have learned by now that the requirement applies only if the parties to the controversy are natural persons. The moment there is a juridical person involved, this requirement does not obtain anymore. And this has been subject of bar problems. One such problem involves property left by a deceased, where an heir immediately brought an action in court, and the same was questioned for not resorting to the conciliation required under the local government code. The legal issue involved is that when a person dies, his estate acquires juridical personality to sue or be sued. So this requirement of resorting to the so-called katarungan pambarangay does not obtain. And although the parties to the controversy before this procedure will apply should be natural persons, there is that limitation that if any of the parties is a public officer and the controversy involves the exercise of his public duties, this requirement also does not apply, because indirectly it will be involving the government. More than this, if the controversy involves real property, the real property must be situated in the same city or municipality where the parties to the controversy reside. Note, it is not necessarily the same barangay. It is enough that they are residing within the same city or municipality. Exceptional to this, which also had been asked in the bar exam before in the form of a problem. Although the parties to a dispute do not reside in the same city or municipality, if, however, their barangays adjoin each other, so this would mean they are residing at the boundaries, so that the barangays may be adjoining each other, then exceptionally they could agree to refer their dispute for conciliation or mediation to the proper barangay. Now, this requirement, although not jurisdictional, because this is not required, but if a motion to dismiss on this ground is filed, the trial court cannot do otherwise except to grant the motion to dismiss. because this is a requirement procedurally before the case should go to court. So, question has been asked about this requirement being jurisdictional. It is not jurisdictional. But when it is raised to question the right of the court to exercise jurisdiction of over the case, the court cannot ignore this requirement under Section 412 of the Local Government Code. Now, although the trust of the provision would require the parties involved in the controversy to first submit their dispute to the proper barangay, yet same Section 412 of the Local Government Code recognizes 3 instances where the parties to the controversy are allowed to go directly to the courts. There are 3 instances where, in spite of the fact that the controversy is covered by the procedure on katarungan pambarangay, yet the parties are allowed to dispense with the conciliation or mediation before the barangay and instead go directly to a court of law. Problem had been given in the bar on this. So a motion to dismiss for the failure to resort to this conciliation should be denied because this is an exception authorized by the law itself. There are 3 such exceptions. Firstly, 1, it would be a criminal case where the offender is under detention. Secondly, 1, the civil case calls for a writ of habeas corpus. And thirdly, 1, the cause of action involved is about to prescribe. Also mentioned as a third ground in the law itself is when the complaint in a civil case is coupled with a prayer for provisional remedy. Now, this is recognized because in these instances, time is of the essence of the disposition of the case. Now, in your preparation for the bar, you give more importance to the exceptions. Problems are generally coined on the exceptional situations because lawyers are supposed to be exceptional. So if you are with the ordinary, then you remain as a layman. You will notice, looking back at bar exams, problems are formulated on the exceptions. That if you are not aware of the exceptions, you will not get the answer correctly. So, in some bar exam, question was asked about the standing of the conciliation agreement that may have been arrived at before the barangay. The provision of the local government code on this expressly provides that they shall have the force and effect of a judgment of a court of law. So that means the rule on res adjudicata will operate here. In fact, also this has been subject of a problem on how the judgment or the award rendered by the barangay will be executed. The provision on this matter authorizes the lupon to execute such judgment within 6 months from this finality thereof, after which such judgment may only be enforced by a summary petition with the court of the first level having jurisdiction over that particular barangay. Over and above this compliance, in the last paragraph of section 408 of this procedure, the courts in non-criminal cases are allowed motu proprio to refer to the barangay within its jurisdiction. Any civil case already filed in court where the court believes that there is possibility of the parties entering into an amicable settlement. Now, this is exceptional in the sense that although the matter is not within the competence of the barangay, so it has been filed directly with the court. If the court believes that there is possibility that the parties could iron out an amicable settlement, the court may motu proprio refer the case to the barangay within its jurisdiction to conduct a conciliation or mediation. Ordinarily, when the barangay conducts conciliation or mediation, it makes a resolution on the amicable settlement arrived at. But in a case like this, where it is the court which referred the matter to the barangay will only submit to the court the terms and conditions of the settlement arrived at, and the court will be the one to render judgment thereon. This provision in the last paragraph of section 408 is often ignored. But this has been subject of a bar problem before. Before the barangay, there are two possible proceedings. One, the conciliation settlement, also known as mediation. The other one is arbitration. But you must have read that arbitration before the barangay can only be had through the pangkat. If the parties to the controversy agreed in writing to submit their controversy to an arbitration. But under the law, the parties may have agreed to submit to a conciliation or mediation or to an arbitration, and yet they are allowed also to repudiate the agreement that they have entered into, provided that they have done so on the grounds specified under the law. There are only 3 grounds for repudiation. 1, on the ground of fraud. 2, on the ground of violence. 3, on the ground of intimidation. Well, these grounds vitiates consent to the outcome of the proceedings. All other grounds not acceptable. No. In the case of a conciliation, the repudiation is allowed to be made within 10 days, because on the 10th day, the conciliation settlement acquires the force of a judgment. In the case of arbitration, the repudiation is allowed only within 5 days. After the 5-day period had lapsed, the pangkat will have to render the arbitration award, and that will be in the nature of a judgment. Failure of the parties to achieve either a conciliation settlement or an arbitration, the case will be certified as proper for filing in court. So the second manner of instituting a civil complaint comes in the filing of the complaint in a court of law. At the initial encounter of the civil procedure, you must be aware of this, because the facts you may encounter may be silent on this, and yet the procedure would not be correct, because the requirement to refer the matter to the proper barangay has not been followed or observed. One problem was given in the bar on this involving an action for forcible entry. The case was filed directly with the municipal court. And the simple question, did the counsel of plaintiff proceed correctly? If you will consider the filing of the complaint under the rules of court, you will say it is correct. But you overlook the requirement that before you could go to court, this is not one of the exceptions where a direct filing in court is allowed, then you will say it's not correct. The lawyer must first initiate his complaint with the local barangay, assuming that the parties are residing in the same place. So you must be aware that there is this requirement. Now, going to the initiation of a civil complaint in a court of law. Second step that would follow would be the commencement of the action in court. This would entail 2 stages. Firstly, the preparation of the proper complaint. You understand at this level the complaint contemplated is different from the complaint contemplated in a case to be initiated in the barangay. Complaint contemplated here is what you have studied in the subject of legal forms. It must state all the elements to make up a cause of action. So in the preparation of that complaint as the first stage of bringing the case to court, you have to reckon with the following points. Firstly, jurisdiction. Before what court should the case be filed? Secondly, venue. Thirdly, the parties to be impleaded. Fourthly, the cause of action to be alleged. Fifth, the relief to be prayed for. Sixth, the signature thereon by the counsel or the party. Seventh, the verification if required. Eighth, a certification of no forum shopping, because the complaint at this stage is an initiatory pleading. All of these will have to be noted by you to determine whether the action was commenced properly. On jurisdiction, you have seen complaints, and there is a heading there. The heading itself discloses in what court the same will be filed. The term jurisdiction has two aspects. Jurisdiction over the subject matter of the litigation, and jurisdiction over the person of the parties or the property or rest involved in the controversy. As far as jurisdiction over the subject matter is concerned, you know this is defined or conferred by law. It is beyond the competence of the parties to invoke this where there is no law providing this within the court to which the controversy was brought. As to the jurisdiction over the person of the parties involved, as far as the plaintiff is concerned, or the one initiating the action, upon the filing of the complaint in court, the court acquires jurisdiction over him. Whether the filing was with the proper court or with the wrong court, plaintiff cannot thereafter assail whatever mistakes he may have incurred in filing the case with the wrong court. He is stopped. Now, it is the other party, the defending party, who may question the correctness of the filing with that court. Now, as far as the person of the adverse party is concerned, whether the court will acquire jurisdiction over his person or not depends on the nature of the case. So you have to analyze the nature of the case involved, whether it is an action in personam or an action in rem or quasi in rem. Of these Latin terms, many students of law equate this with personal actions in respect of action in personam, real action in respect of actions in rem. That is wrong. The classification of action, whether it's personal or real action, depends on the nature of the subject matter of the controversy involved. On the other hand, the classification of actions as in personam or in rem or quasi in rem depends on the binding effect of the judgment that may be rendered in that action. It is an action in personam if the judgment that may be rendered in that case will bind only the parties impleaded and their privies. It is an action in rem if the judgment that may be rendered will bind all who are minded to challenge the judgment that the court may render. And it is an action quasi in rem if the action, although directed against a particular dependent, will however bind property involved therein against anyone who may be minded to lay a claim on the property involved. Now, when the action is one in personam, jurisdiction over the person of the dependent may be acquired depending on this. Firstly, whether the dependent is a resident of the Philippines and within the Philippines. Or, secondly, the dependent is a resident of the Philippines but outside of the Philippines temporarily. If you have read Rule 14 of the Rules of Court, you should notice this, that jurisdiction is acquired as to the person of the adverse party, depending on the nature of the action, and depending on whether the adverse party is temporarily out of the country or within the country at the time the case was filed. Now, as far as dependents who are within the Philippines and resident of the Philippines at the time the action is filed, jurisdiction may be acquired, firstly, by voluntary appearance and submitting to the authority of the court, or secondly, through personal service of summons, or thirdly, if personal service of summons could not be made promptly through substituted service of summons. So if the service of summons was not done in accordance with this modes, the court will not acquire jurisdiction over the person of the defendant. The court, therefore, cannot render a valid judgment against the defendant. On the other hand, where the adverse party is out of the Philippines temporarily, although he is a resident of the Philippines, jurisdiction over his person may be acquired, firstly, through voluntary appearance or personal service of summons. Under Section 15 of Rule 14, you have there the so-called extrajudicial service of summons, but with leave of court. Thirdly, substituted service of summons. If personal service could not be done promptly. Then fourthly, through publication. It is here where summons by publication is authorized. And you have to underscore this under Section 8 of Rule 14. Any other ways that the court may deem sufficient in the premises. This particular insignificant phrase in the rule was the basis of a bar problem given in remedial law not so long ago. The service of summons may not be in accord with the enumerated ways, but if the court regards it as sufficient to inform the adverse party that a case was filed against him before a Philippine court, he will be bound by the processes of that court. This is so because the adverse party, after all, is a resident of the Philippines, although temporarily out of the country only. Now, where the action is one in rem or quasi in rem, it is not necessary that before the court can acquire jurisdiction over the case, it should first acquire jurisdiction over the person of the defendant. The court may acquire jurisdiction over the property subject of the controversy ahead of jurisdiction acquired over the person of the defendant. And the proceedings will then be valid after all. Of this different service of summons to acquire jurisdiction over the person of the adverse party, commonly subject of bar problems, is the substituted service. The provision on this, as worded, seems to imply that if service in person to the defendant could not be made within a reasonable time, substituted service may be made, provided that it shall be made to one who is also residing in the same place where the defendant resides, if personal service is to be made there, or if personal service is to be made at the office or place of business of the defendant, the substituted service should be made to a person of sufficient age and discretion who is in charge of that office or place of business. This is not really the interpretation made by the Supreme Court of the provision on substituted service. It is the impossibility of serving the summons in person to the defendant within a reasonable time. So the mere fact that the defendant was not at his house where the summons was addressed at the time it is to be served on him is not enough to authorize the sheriff to resort to a substituted service. In a case where the defendants are spouses, summons was addressed to their residence. So, at the time the sheriff came to serve summons, only an elderly woman who happened to appear as their house help was there to receive the summons. And she informed the sheriff that the dependent husband was somewhere in Bicol, while the dependent wife was abroad. So the sheriff wrote this. Eventually, the dependent husband learned of this and challenged the validity of the court's acquiring jurisdiction over the person of the defendant. Supreme Court nullified the service done purportedly in a substituted manner. The return of the sheriff did not state that due diligence was taken or earnest efforts exerted to determine where in Bicol the dependent husband was at the time when he would be returning. So, also, as to the dependent wife who is abroad, when she will be returning. And the High Court said, the dependent may not be at the place where summons is to be served at the time the sheriff is to serve them summons. If, however, there is an indication that they would be there within a reasonable time, the sheriff must return and serve summons personally to the defendant. So it is not really in the loose sense of the word substituted service. It is only allowed in lieu of service in person to the defendant if there is no possibility of serving the defendant with the summons within a reasonable time. As to the so-called voluntary appearance, Supreme Court in a recent case promulgated last year called attention that where the defendant filed a motion to dismiss, precisely challenging the manner summons was served, that will not be regarded as voluntary appearance. The voluntary appearance referred to under the rules is that which is unqualified by any other reason. See now. So it must be one where the defendant submits himself or herself to the jurisdiction of the court as far as the case involved in the summons is concerned, but filing a motion to dismiss on any ground that assails the exercise of jurisdiction by the court over the person of the defendant is no voluntary appearance at all. The court cannot proceed on that basis to render a valid judgment against the adverse party. This was the ruling in this case of General Garcia, promulgated only October 2009. And this again amplify concept of importance of serving summons to a defendant. Where the defendant had been served with summons, jurisdiction over his person is acquired. He must react to the summons either way allowed him under the rules of court. But referring to the other items to be considered in the preparation of the complaint, you have there, next item is venue. The place where the court in which the case is to be filed is sitting or holding session. In this regard, you must have noticed that in civil cases, the place where the court is holding session in which the case is to be filed is only a matter of venue which the parties are free to agree upon. But in a criminal case, the place where the court is required to act on the case is not only a matter of venue, it is jurisdictional. And this is what is referred to in criminal procedure as territorial jurisdiction, not subject to agreement of the parties. Only a proper petition to the Supreme Court moving the venue of the action to a proper case will authorize any other court to act on the case. How about venue? You should know how this is distinguished from jurisdiction. This has been asked countless times in bar exams. In civil cases, as I said, venue is for the convenience of the litigants, hence subject to their agreement. In criminal cases, it is not so. Our jurisdiction, referring to the subject matter, cannot be subject of any agreement. It is conferred by law. Jurisdiction is substantive. Venue is procedural. Regarding this subject of venue, the issue here is on the binding effect of an agreement of the parties as to the venue of any controversy that may arise between them. Now, the point that you should look into is whether the agreement of the parties is restricted or excludes any other place, in which case that agreement, which in civil law is the law between the parties, must be honored. Filing the action in any other place limited by the agreement of the parties would render the filing of the action as null and void. So it is a question of whether the agreement to bring the controversy in the proper court fixed by the parties is exclusive of all other venues or not. If there is no indication there using the word exclusively or the word only to denote that the agreement excludes all other places, then the jurisprudence here holds that the agreement is only in addition to what the rules of court has laid down. So the parties to the controversy, despite the agreement, may still file the case in the court, which under the rules of court is the proper venue of the action, although disregarding what was agreed upon. Where, however, the agreement was exclusive of all other venues, even though the case is filed with a court defined under the rules to be the venue of the action, the same will not hold, because the exclusive or restrictive nature of the agreement will be the one upheld. There is, however, an exception to this, where although the agreement of the parties excludes all other venues, if, however, the agreement would amount to a stipulation that would deny pre-access to the courts, that agreement will partake a stipulation contrary to public interest and therefore will be disregarded. So if, let us say, the parties who transacted agreed that any controversy between them regarding the subject of their business transaction would be filed with the proper court in Bacolor, Pampanga only. But it turned out that this Mount Pinatubo had exploded and all the places there were buried in Lahar. To expect that the plaintiff would enforce his right under the agreement in the court at that place would be asking the impossible. And that would therefore amount to a stipulation denying pre-access to the court, which is a constitutional right. In that case, the agreement, although exclusive of all other cases, will be regarded as not entered into at all because it amounts to a stipulation contrary to public policy. As to the next factor to consider in the preparation of the complaint, the parties to be impleaded. Here, you consider whether the party to be impleaded is only a necessary party or an indispensable party. Now you know which is which. What is more important here? Although a party which is indispensable in a litigation would render all proceedings there null and void if that party was not pleaded at all. Yet, the fact that an indispensable party was not pleaded in an action is not a ground for a motion to dismiss. This is expressly provided for under the rules. Misjoinder or non-joinder of parties in an action is not a ground for dismissal. And this has been subject of repeated bar problems because the logical assumption is that since an indispensable party is necessary to arrive at the resolution of the case, if he has not been pleaded, then nothing can happen. And therefore, it only would be a waste of time. The party pleaded, therefore, may simply file a motion to dismiss the case. So you have an express rule, contrary to that thinking, that non-joinder or misjoinder of parties who should be joined is not a ground for dismissal of the case. No. About the parties to be pleaded, also important for you to understand is the rule on joinder of parties. The rules of court incline towards avoidance of multiplicity of suits. So when a particular step had been taken, although not sanctioned by the rule, would be in effect upholding the rule against multiplicity of suits. On this argument, the deviation from what is ordinarily required may be allowed, especially where no injustice would result to the other party. Next is the cause of action. Now here, you have to understand the legal difference between a cause of action and a right of action. Does not follow that because the plaintiff has a right of action that he will have a cause of action. Cause of action is determined by the allegations in the complaint, the pleading filed by the plaintiff. He may have a right of action under the law violated, but if the allegations in his complaint does not make out a cause of action, the adverse party, the defendant, can move for the dismissal of the case on the ground that the complaint states no cause of action. For example, in a complaint for unlawful detainer, where the defendant's right to keep possession or occupancy of the premises is involved, the same was violated, not because of the expiration of the term of the agreement, the rules require that there be a demand to vacate. And this must be alleged in the complaint for unlawful detainer. Failure to make any such allegation, even though in fact the defendant had violated the lease agreement with the plaintiff, the complaint states no cause of action. To understand the difference between the right of action and the cause of action, you recall as a rule of procedure that when a motion to dismiss is premised on this ground, that plaintiff's complaint states no cause of action, the court, in resolving that motion, is allowed only to confine itself on the allegations in the complaint. If the allegations in the complaint does not really make out the requisites under the rules, even though evidence outside of the complaint would show that the plaintiff has a right that was violated by the defendant, the court will be acting in error. Because on this ground, for a motion to dismiss, the court is limited only to what are alleged in the complaint. The court cannot receive any evidence outside of the complaint, because whether or not the plaintiff has a cause of action is determined only by the allegations in the complaint. Outside of that will be a right of action already. You must have learned that under the old rules, when the complaint fails to state a cause of action and the defendant successfully filed and maintained a motion to dismiss on this ground, the plaintiff cannot just amend the complaint. The plaintiff must file a new complaint where it will state a cause of action. Otherwise, the premise then was that a complaint which does not state a cause of action is no more than a scrap of paper. So no amendment can rectify the same. Under the present rules, however, even when the complaint does not state a cause of action and the defendant filed a motion to dismiss on this ground, successfully showing that the complaint does not state a cause of action, if the same deficiency could be corrected by mere amendment under Section 5 of Rule 10, the court may simply order the amendment of the complaint to allege a cause of action there. This was subject of a bad problem not so long ago because of the change in the rules. However, although this is the provision of Section 5 of Rule 10, in a subsequent ruling, the High Court clarified that this is only proper if indeed at the time the complaint was filed, the plaintiff already has a right of action. Because if at the time the complaint was filed, the plaintiff has no right of action, no case filed in court shall acquire its standing in court. So an amendment will not suffice. So you have an exception and an exception to the exception. This also was subject of a bar problem in a more recent bar exam. See. Now, similarly, on the matter of venue, under the former rules of court, where venue was improperly laid, the defendant can only question the improper venue in a motion to dismiss. So where this ground is to be raised, the defendant has no choice but to file a motion to dismiss. And not only that, if the defendant filed a motion to dismiss on this ground that venue was improperly laid, he should not raise any other ground in the same motion that would invoke the authority of the court to resolve the other ground raised in the same motion. Otherwise, the ground of improper venue is waived. Now, under the present rules, even where improper venue is a ground for a motion to dismiss under Rule 16, the defendant is now allowed a choice between filing a motion to dismiss on any of the grounds for dismissal under Rule 16 or simply to file an answer where any of the grounds for a motion to dismiss may be raised as an affirmative defense. And before trial may commence, the defendant may file a motion for preliminary hearing on that ground, which should be made a ground for a motion to dismiss, so that the same may be dismissed or, if allowed, may be corrected by proper order of the court. This is now the standing of the rule. Now you may be reading commentaries where the publisher has been adding and adding so many things there without expunging those rules, which have become obsolete. So you will be misled. You be guided by these changes. Because I understand the forthcoming examination will be basic. No surprises. So at this stage, what you should review on is how you formulate your reasoning, how you lay down the premise, major premise, minor premise, then the conclusion. And not just to make any reason there haywire. No. Now going further, one of the matters to be brought out in the preparation of the complaint is the prayer for the relief to be asked. Now, the requirement here is that the relief prayed for must be authorized by law. what the law does not allow, a litigant cannot pray for. Or even where the law allows a certain relief, the allegations in the complaint must lay a basis for the relief to be prayed for. So if the pleader would make a prayer for a relief authorized by law, but the allegations in the pleading does not provide a foundation for that relief, the court did not acquire jurisdiction over that issue and therefore cannot grant a relief which has no basis in the pleadings. So now, on the other hand also, although under the allegations in the pleadings, the pleader has a right to pray for a particular relief, but if he did not pray for that relief, the court cannot grant this motu proprio. Court cannot be more popish than the Pope. Only that which is asked shall be granted. That which is not asked, the court should not grant. So, no. That is why you will recall in pleading making, there is always a catch-all provision there. At the conclusion of the pleading, there is that allegation, further plaintiff prays for such other relief as this honorable court may consider just and equitable in the premises. That prayer is intended to cover specific reliefs which the pleader may not be aware of, but which the law grants under the situation presented by the pleadings. That's why there should always be that specific allegations. With that will now come the signature on the pleadings. This matter has been asked twice already in the bar exam. The significance of a lawyer signing a pleading. Specifically, Section 3 of Rule 7 provides the implications when a lawyer signs a pleading. So, a new lawyer is eager to sign as though he is signing an autograph. So, understand that the signature of a lawyer as made in the rolls of attorney carries with it a legal implication. And there are three. The lawyer's signature on a pleading is a certification that he has read the allegations of the pleadings. If there is anything there that turns out to be false, and he cannot claim that he did not read this, he is stopped because having signed this brings about a certification that he has read the same. Moreover, that signature in effect certifies that there is a good ground to support the allegations in the pleadings. So if these were found to be sham or not genuine, the lawyer has no excuse. And thirdly, that the pleading is not interposed for delay. Under the amendment made by the Supreme Court circular on a resort to this petitions for certiorari, anything found to be false will bring about treble cost and attorney's fee to the adverse party. And the lawyer will be sanctioned for having signed such petition. Because that petition is filed with the Supreme Court, and it will bother the time of the Supreme Court. If it was the party who signed the pleadings, the consequence of any falsehood or any inaccuracies or distortions made will bring about striking out of the pleading from the records of the case. Here, it brings about an implication that if a party is represented by a counsel and yet the counsel does not sign, it is the party who signed, this is an implication that there is something wrong in the allegations in the pleading, that the counsel would not want to risk his neck signing the allegations therein. So now, next matter is the verification. Only those pleadings required by specific provisions of the rules to be verified, like those governed by the rule on summary procedure, like forcible entry and unlawful detainer cases, require that the same be verified. The verification now specifies the wordings to be made, whereas before, a verification based on information and belief is acceptable, now no more. Verification to be properly regarded must be made on personal knowledge or on the basis of authentic records. Anything outside of this will be a violation of the required verification. When the pleading required to be verified is not verified, the same shall be treated in the same standing as an unsigned pleading. And that means it has not become part of the records at all. Or if this would be required to be filed within a certain period, the verification has not been made within that period, then there is a failure to file a responsive pleading that is required to be verified. That will be the consequence. Lastly, the required certification of non-forum shopping. You must understand that this certification requires the party litigant himself to sign the certification. The lawyer is not authorized to sign the certification. Now, moreover, the improper wording of the certification cannot be corrected by amendment. And under the rules here, Section 5 of Rule 8, if there would be an indication that the pleader deliberately avoided the required certification, that would bring about the consequence of direct contempt. It is only when the pleader apparently tried to comply with the certification but failed to accomplish this in the tenor required by the rules that the consequence will be the same, except that instead of direct contempt, it is only to be regarded as indirect contempt. But just the same, the pleadings filed will have no standing in court, cannot be amended to comply with the requirement. You must be familiar with the allegations laid down under Section 5 on this matter, because the certification must substantially comply with the allegations required there. The rules would not have laid down these allegations if these are not controlling. So in a case where the certification followed the details except the last one, where the litigant certifies that should he learn that there is another case pending with any other tribunal involving the same subject matter or issues, he shall report this to the court within a period of 5 days. On this particular allegation, the pleader did not state any period of 5 days, but he stated only within a reasonable time. So the adverse party questioned this as non-compliance with the requirements of the rules. The issue was elevated to the Supreme Court. Supreme Court ruled there is no compliance at all. That means the pleading is deemed to have not been filed at all. This is a provision that may be fatal to the progress of a case because of the failure of a party to comply therewith. Compliance, however, is true only to initiatory pleadings unless the rules on a particular case, although the pleading is merely a continuation of what had transpired in the court below, the rules require a certification of non-forum shopping, in which case, although it may not be regarded as an initiatory pleading, but a continuation only of the proceedings in the court below, because the rules require that it must be accompanied by certificate of non-forum shopping. The failure to comply with it would amount to a non-compliance with the rule for the remedy chosen by the pleader. Although there is no requirement about certification of non-forum shopping, if it was an initiatory pleading, it follows this requirement obtains. Generally, an answer is not an initiatory pleading. It is the complaint that is the initiatory pleading. But if the answer pleaded a permissive counterclaim, insofar as that permissive counterclaim is concerned, the answer is an initiatory pleading, and therefore it must comply with the required certification of non-forum shopping. If that answer was silent on this requirement, you get it clear. Not the whole answer will be rendered useless, but only pro tanto, the allegations in respect of the permissive counterclaim. The other matters alleged in the answer not being part of the initiatory allegation will stand. I do not think the entire answer is reduced to a mere scrap of paper. That's wrong. Only the allegations relevant to the permissive counterclaim. So, now, after this, the next step in the commencement of the action in the court of law is the payment of the required filing fee. And you must have learned by now that the filing of the pleading with the clerk of court does not satisfy the required response or the required initiatory step to commence the action. It is the payment of the required docket fee, payment of the correct amount of the docket fee. Where the subject of the litigation is incapable of pecuniary estimation, the docket fee is fixed in amount. Where the pleading involves real property or interest therein, filing fee is based on the declared assessed value of the real property involved or the zonal value determined by the BIR for taxation purposes, whichever is higher, that shall determine the correct amount of the docket fee. On this point, you must have come across the leading ruling in Manchester Development versus Court of Appeals, followed by the more liberal ruling in Sun Insurance Office versus Court of Appeals. In the Manchester ruling, the failure to pay the correct amount of the docket fee brought about the dismissal of the entire complaint. And the dismissal, being at that stage where trial had already commenced, was considered to be with prejudice. That means cannot be refiled or reinstated anymore. That is because in that case, the plaintiff tried to play around with the court, making amendment to pay a smaller filing fee, and if it succeeded to adduce evidence on a bigger amount, then it amends again to pay a higher amount of filing fee. And if it also meet the opposition of the adverse party, it will again amend to lower it. And there was some sort of speculation. So the trial court noticed that the pleader was in bad faith. So, dismiss the case. This was modified in that case of Sun Insurance Office versus Court of Appeals to the effect that if the correct amount of the docket fee was not paid, trial court may direct the pleader to pay the deficiency. Payment of the deficiency, however, will only render the filing of the pleading as having been done as of the date the full amount of the docket fee was paid, not on the date the pleading was filed, while an amount lesser than what is required to be paid was paid. The payment of the deficiency in the docket fee will only serve the purpose if it was done before the cause of action has prescribed. If the cause of action has already prescribed, payment thereof will not validate the case filed by the plaintiff, because it is not at the time the case was filed that will determine whether the cause of action has prescribed or not, but rather at the time the correct amount of the docket fee was fully paid. It is only then that the case shall be considered filed. So if at the time the full amount was paid, the cause of action had already prescribed, no more. The order of the court directing the litigant to pay the deficiency cannot be capitalized on to render the case still in good standing. If it has prescribed, it has prescribed. So this is the prevailing rule here. Now you must note that the rule on the payment of the docket fee has been amended. Now you must have learned that when the defendant pleads a compulsory counterclaim, there is no need to pay docket fee, because a compulsory counterclaim partakes the nature of a defense, not a claim. But under the amendment made to the rule on docket fees, even compulsory counterclaim requires payment of the docket fee. So otherwise, compulsory counterclaim, which operates as a defense, cannot be discussed at the trial if, after all, no docket fee was paid therefore. Moreover, on this point, you must have learned before that if the counterclaim was compulsory, there is no need for the adverse party, the plaintiff, to answer or respond thereto. Now, it is required if, after all, the compulsory counterclaim is based on matters which are not alleged in the original complaint, and therefore the basis thereof is not found in the complaint of the plaintiff, but rather brought about as a new matter in the defendant's answer. In such a case, the plaintiff is required under the new rules to join issue with the allegations constituting the compulsory counterclaims. These are new matters that you should take note of. So after this, we move on to the serving of summons to the defendant. Before we proceed, it's time for you to have your break. So let us have a brief break. Then we resume up to 9 o'clock. Let us resume. Incidentally, if you have some doubt of the situation you may have in mind, write it down, and I will endeavor to enlighten you in our free time. I'll be meeting you for 3 days. Now, regarding the third step in the chronology of the procedure, you have the service of summons. Of this service, as I have discussed with you earlier, the more important for you to understand is the substituted service, because the wording of the provision on this does not reflect the actuality as applied by the Supreme Court. With the defendant having been served with summons, relative to this, if the summons was improperly served, the defendant may file a motion to dismiss on the ground that the court did not acquire jurisdiction over his person, or the defendant may simply file an answer and allege this as one of the affirmative defenses that he may invoke. And before trial proceeds, he may file a motion for preliminary hearing to resolve the propriety of this. You should understand, however, that although summons was improperly served, if the defendant was actually notified of the case filed against him, he should not capitalize on the wrong manner of serving summons. He should inform the court of that impropriety, as otherwise the court has a right to rely on the presumption of law that the sheriff, being a public officer, performed his duties with regularity. It is only when the defendant, because of the erroneous service of summons, did not learn of the case filed against him, that the service shall be declared null and void. Otherwise, he will be bound, because then he would be taking advantage of the error committed by the sheriff, which has not been brought to the attention of the court, which will decide the case against him. or you may have come across decisions where the Supreme Court upheld the binding effect of the process, although the rules on this was not observed. And that is in order to dispel the bad faith on the part of the defendant in avoiding the judicial process served on him. You have to weigh which would be in keeping to achieve substantial justice. After the defendant had been served with summons, the next step comes in where he should react to the summons served on him. The options available to him under the rules of court are: firstly, file a motion to dismiss. And this is grounded on those mentioned in Rule 15. The important ground here, I already told you earlier, is where the complaint fails to state a cause of action. The rule has law significance because of the liberalization of the rule on amendment. The rules incline to allow the pleader the benefit of an expeditious settlement, that even though the ground is proper, if the dismissal of the case could be avoided by instead directing the pleader to amend, the better option is for the court to require the pleader to amend. Now, of this ground, you have to understand these grounds which will bring about a dismissal of the case because the error cannot be corrected by amendments. Now, another option available to the defendant under the rules is to file a motion for bill of particulars. Now, here, the new rule of civil procedure renders this option available only if the allegations in the plaintiff's complaint lacked materiality on what should be particularized, so much so that the defendant is prevented from filing an intelligent answer. As against the rule on this before, now the present rules allow a bill of particulars only if, without the particularity moved for by the defendant, the latter cannot file an intelligent answer. Before, even when the defendant had filed an answer, if there would be details that he needed for entering a trial, he is required or he is allowed to move for a bill of particulars. The new rules now do not allow a motion for bill of particulars once the defendant had already filed an answer. Therefore, this option is limited only to a situation where, without the particularity asked by the defendant, he could not file an intelligent answer. The reason for removing the availability of this option for purposes of trial is that if there was any matter that the adverse party cannot understand, he can resort to any of the different modes of discovery and not delay the proceedings by simply asking for a particularization of matters which are not necessary in this stage of filing pleadings. This point has been subject of a bar problem not so long ago because of the change brought about by the new rules, where a motion for bill of particular is now allowed only for purposes of the defendant's filing an intelligent answer, not for any other purpose anymore. Now here, you should give attention to the requisites of the rules for a motion for bill of particular to be considered meritorious. Otherwise, the motion becomes pro forma, and the same shall be denied. First requirement, the motion must point out the defects in the allegations in the complaint which the movement requires to be particularized. Second, the movement must specifically state the details needed for him to be able to file a responsive pleading. The rule on this mentions of these matters. Failure to comply with this would render the motion pro forma, and the allowed period of 5 days, an extension within which the movement may have to prepare his answer, will not follow. Another option available to the defendant is a motion for summary judgment. This is provided for in Rule 35 of the Rules of Civil Procedure. A motion for summary judgment is available on the premise that the plaintiff's cause of action is not genuine. The complaint under this situation alleges a cause of action, but the defendant is possessed with depositions or any other competent evidence, or there are available affidavits to establish the non-genuineness of the plaintiff's cause of action. If the non-genuineness of the plaintiff's cause of action could be established by affidavits, depositions, admissions, or other competent evidence in law, a trial on the merits would be unnecessary. The defendant may instead move for a summary judgment. The motion must be supported with enough evidence to show that there is no need to go to trial because the non-genuineness of the plaintiff's cause of action is clearly shown. This option is available not only to the defending party but also to the plaintiff. You notice under the said rule that this is an option available both to the plaintiff and to the defendant, depending on whose pleadings would be assailed for non-genuineness of the allegations therein. The point commonly involved in the problem here, although it had been shown that most of the allegations in the pleadings of the adverse party are no longer requiring a trial. If there would be any issue of fact that would require reception of evidence, a summary judgment is not allowed to be rendered by the trial court. This was subject of a bar problem in one of the recent bar exams. The erroneous concept of trial courts of what a summary judgment is has been rectified in recent rulings of the Supreme Court. I would advise you to give some readings on this matter, summary judgments, because you are likely to encounter this again as a step of expediency. Trial court judges on this motion readily grant this so that they do away with the intricacies of a trial, not knowing that the more it would prolong and delay the disposition of the case. Also ask relative to summary judgment is the so-called judgment on the pleadings. You should know the difference between summary judgment and judgment on the pleadings. Both judgments are obtained by mere motion. So there is no trial on the merits. A summary judgment, however, is generally available both on motion of the defendant or on motion of the plaintiff. But a judgment on the pleadings is available only to a claimant. A plaintiff, insofar as the cause of action is concerned, or a defendant, insofar as a permissive counterclaim is concerned. In a judgment on the pleadings, the court is allowed to go over the allegations of the pleadings only. The court cannot resort to any other evidence outside of the pleadings. Whether judgment would be worthy in the premises will depend on what had been alleged in the complaint and in the answer. The pleadings referred to are only the complaint and the answer. No extraneous evidence can be inquired into by the trial court to determine whether the motion is impressed with merit or none at all. But in summary judgments, the motion for this purpose requires that it be supported by affidavits of merits, depositions, admissions, and other evidence that would show that there is no need for a trial because the allegations in the plaintiff's complaint or the defense raised in the defendant's answer are not genuine. In other words, summary judgment is not confined to the allegations in the pleadings of the parties. Now, the remedy is available both to the plaintiff and to the defendant as the case may be. Now also, for availing of this benefit of a summary judgment, the rules allow the movant a period of 10 days notice to the adverse party before the hearing of the motion to that effect may be set. While in a judgment on the pleadings, the motion is governed by the usual 3-day notice. Academically, you have these distinctions. And you must be at least knowledgeable on this, considering the common report that this bar exam will be basic. It will really dwell on what you are supposed to know and have learned in the classroom. See now. Now, with these options available to the defendant is given a period of 15 days within which to file his answer. But you must also know that there are instances where the defendant is allowed a period of 30 days to file his answer, or even a period of not less than 60 days. Any of these options are available to the defendant within the period for filing his answer. So if under the circumstances he is required to file answer within 15 days, any of these options must be availed of by him within 15 days after service of summons to him. Or if the period for answering is 30 days, then he should avail of any of these options within 30 days. You will recall that when the defendant is a juridical entity doing business in the Philippines but without any resident agent here, summons shall be served upon the government office charged in law with the supervision of that business of the defendant. And the government office here will in turn notify the defendant thereof. The defendant then has 30 days after such notice within which to file his answer. Moreover, in those cases where serving summons by publication is authorized, the defendant will be informed of the summons through the publication ordered by the trial court, because serving summons by publication is always with leave of court. The court then, in its order granting leave, will have to specify a date not less than 60 days after such publication, within which the defendant should avail of the options under the rules of civil procedure. Now, in such a case, the period available to the defendant for filing a motion to dismiss, or motion for bill of particulars, or motion for summary judgments would be within 15 days, 30 days, or at least 60 days, as the case may be. Where this period had lapsed and the defendant has not yet filed any of these options, the plaintiff will then acquire the right given him under the rules of civil procedure to make his own moves. Under the rules, the plaintiff is allowed to resort to any of the following options after the defendant had already exhausted the period for filing these options available to him, whether he availed of this or he failed to avail of this. The options available to the plaintiff then are the following. Firstly, a motion to declare the defendant in default. This is proper in the following situations. Firstly, where the defendant did not file an answer within the reglementary period required under the summons. Or, secondly, the defendant filed answer but beyond the reglementary period for filing answer. Where the defendant filed answer beyond the reglementary period allowed under the rules, that answer will stand as a mere scrap of paper. It has no judicial standing at all. So if a defendant would be late in filing his answer, he must accompany this with a motion to admit the answer. The motion will state the merits of why the answer should be admitted. And if the motion would be granted by the court, automatically the answer attached to the motion will be deemed admitted. Now, third situation where a declaration of default is proper is where the defendant filed the answer in court but legally failed to serve copy of the answer to the plaintiff. Our relative to this, legally, the defendant may have served copy of the answer to the plaintiff, but in law, that answer has no valid standing. Under Section 11 of Rule 13, if any pleading or motion filed by a litigant was not served personally to the adverse party, the same requires an explanation why it was not served personally to the other party. Failure to make such explanation would render the pleading, the motion, or whatever paper he filed as though it was not filed at all. This Section 11 of Rule 13 is a new provision of the Rules of Civil Procedure. So you give attention to this. Factually, the defendant may have served answer. If that answer was served by registered mail, and there is nothing in the bottom of that answer making an explanation of why the same was not served personally to the defendant, failure to make that explanation renders the answer as not filed at all. The consequence, a default. Give attention to this. This is a new rule. So given a situation where the defendant filed answer, copy served to the plaintiff was sent by registered mail, but there was no explanation why it was sent by registered mail, the effect would be one of default. Under the new rules now, a declaration of default against the defendant can no longer be obtained ex parte. A motion to this effect is now in the nature of a litigated motion. The provision on this under Rule 9 provides for a due hearing of the motion to declare the defendant in default. That means the defendant must be served with a motion through proper service thereof. And a hearing will have to be conducted by the court which should try the case. On this default brought about by the failure of the defendant to file his answer as required by the rules. No. The consequence of a declaration of default under the present rules is substantially different from the consequences under the former rules. Currently, even though the trial court may have granted, after due hearing, the motion to declare the defendant in default, the defendant does not lose his standing in court. The defendant only loses his right to participate in the trial of the case. As far as his right to be served with copies of whatever motion, pleading, orders that may be filed or issued in the case, the same remains. The defendant is entitled to be served with any and all legal papers that the plaintiff may file in court after the defendant was declared in default. More so, final orders and judgments that the court may render. On this situation, you must also be conversant with the remedies available to the defendant against a declaration of default. Under the old rules, even when the defendant is declared in default, plaintiff was still required to adduce evidence to prove his cause of action. Only the reception of the evidence will be taken ex parte. Now, this is no longer necessary. The new rules authorizes the court, upon a declaration of default of the defendant, to immediately render judgment against the defendant on the basis of the plaintiff's allegation in his complaint. But the court is authorized to mitigate the damages that the plaintiff may claim, and the court is limited to accord only that relief prayed for in the complaint without altering or changing the nature thereof. So if the action is one for a specific performance, the defendant was declared in default, even though it is more expedient for the court to declare a rescission of the contract, it's not allowed to validly do the same. A court in a default judgment cannot render a judgment different from what is alleged in the complaint. Also now, the common provision that if there were more than one defendant to a case, others file answer, others did not. Those who did not file answer may yet be declared in default, but not for a judgment by default to be rendered against them. The judgment by default will not be proper because under the new rules now, the case will be tried on the basis of the answer filed by the answering defendants. This is proper, however, only when the defendants are sued in a cause of action common to all of them, and the answer filed by the answering defendants is not personal only to him who filed that answer. So the defense raised in the answer of the answering defendant is equally applicable to the other defendants. But if the defense raised in the answer of the defendant who filed this was personal only to him, like minority of the defendant, the other defendants who had been declared in default for not answering cannot ride on that defense because it is personal only to the one who filed his answer. So you understand this in this line. Or if the answering defendant died after filing the answer, the others cannot invoke whatever defense he had raised in his answer. These are the consequences of a default under the new rules. The problem given in the bar on this is where the court exclude the defaulted defendant altogether from the trial going on. And that is a material change brought about by the new rules. As I said, the defendant does not lose his standing in court. What he loses only is the right to participate in the trial of the case. As far as his entitlement to be served with copies of any motions or legal papers that the plaintiff would file, that right remains. So now also here, subject of a problem before was an oral declaration of default moved by the plaintiff against the defendant. As I said, this is not allowed anymore. The resolution of a motion to declare in default must be after due hearing. So notice of that motion must be served with the defendant properly. Otherwise, the declaration of default would not be valid. Where the declaration of default was lifted, whatever proceedings had already taken place before the declaration of default was lifted will stay. See, the lifting of the declaration of the defendant as in default will only give the defendant the opportunity to interfere or intervene at that point where his standing is restored, that he can participate already in the trial. So the testimonies of the witnesses already taken will stay. So, it is in this respect that the new rules brought about a change in the proceedings where a defendant had been declared in default. An opposition to a motion for a declaration in default would no longer be proper if the court has already rendered a judgment by default. The move of the plaintiffs or the move of the defendant against such declaration of default is to set aside the judgment by default already rendered. The grounds allowed for this are limited only to fraud, accident, mistake, or excusable negligence. And whenever these grounds are available under the rules of court, always an affidavit of merit is necessary to explain under oath how the fraud, the accident, the mistake, or the excusable negligence took place, to show that it came about without fault on the part of the movant. Moreover, the defendant, in the same affidavit of merit, must establish that he has a valid and meritorious defense. Merely substantiating the fraud, the accident, the mistake, or the excusable negligence will not bring him anywhere if, after all, there is no showing that his defense, if allowed, would be meritorious. So these two things must be established. Another move available to the plaintiff against the defendant is a motion for judgment on the pleadings. The important aspect of this option, as I mentioned a while ago, is that the court acting on such motion is confined only to the allegations in the plaintiff's complaint and the allegations in the defendant's answer. Do not mistake this for a situation of default. This is a second option where the defendant has filed an answer, but the allegations of the answer failed to establish an issue. No issues have been joined. Now, in procedural law, we say no issues have been joined if the pleadings of the adverse party does not deny the allegations in the pleader's complaint. See? So you notice this, where the defendant did not file an answer, default. The defendant filed an answer, but the defense raised are sham or not genuine, remedy is a motion for summary judgment. Where the defendant filed an answer, the answer filed on time, there is a defense raised there. But the defense does not tender an issue. This is brought about by implied admission. See? It is rare that the pleader would file a pleadings and expressly admit while the other party has alleged. The admission generally results from the failure to comply with the requirement of the rules on how the denial should be made. Now, relative to this, when a plaintiff moves for a judgment on the pleadings, I said that the resolution of such motion by the trial court will be confined only to the allegations in the complaint and the allegations in the answer. No outside evidence shall be allowed to be received by the court in order to resolve such motion. Now, what is the implication of this? You must have learned by now that any damages being claimed by a litigant must be established with evidence except liquidated or stipulated damages. All other damages are not subject to admissions. This always requires proof. So if the plaintiff filed a motion for judgment on the pleadings, the claim for damages in his complaint, which are not stipulated or liquidated damages, are likewise foregone, because he is barred from adducing evidence to support any of the allegations in his complaint. The option authorizes the court only to consult the pleadings on file. At this stage, the pleadings on file are only the complaint of the plaintiff and the defendant's answer. Outside of that, no more. In effect, therefore, those damages which are not stipulated or liquidated damages are deemed abandoned or waived. If the court, therefore, will grant in the judgment any such damages, that grant is not valid. Because it is deemed abandoned and waived. The court then would be acting in excess of jurisdiction in granting damages which, after all, has not been established. Basic is the rule that no damages may be recovered without being proven. So these are the after effect or consequences of a motion for judgment on the pleadings. Generally, it is an option available to the plaintiff, a claimant. But if the defendant's answer pleaded a permissive counterclaim, the defendant may also avail of this insofar as the permissive counterclaim is concerned, provided that the permissive counterclaim stands. Because, as I said earlier, if the defendant's answer pleaded a permissive counterclaim, it would require a certification of non-forum shopping. Otherwise, it will be deemed as not alleged at all. Or, if the defendant answer pleaded a permissive counterclaim and the required docket fee for the permissive counterclaim has not been paid, that counterclaim will have no standing in the trial of the case. You know that a permissive counterclaim stands as a complaint by the defendant against the plaintiff. So whatever are required of the plaintiff in respect of his complaint will also be assumed by the defendant in respect of his permissive counterclaim. If you could follow the interchange of the moves made by the rules of court to be available to both litigants, it is easy for you to keep track of any situation that you may encounter in a civil action. What is incumbent on you is to identify at what stage the case has already reached. Whatever you will say or write at that stage should not involve other stages. Otherwise, it will only hint that the examinee does not understand really the procedure. In other words, you have to isolate the situation brought about by the problem. In that way, you understand how the flow of the procedure goes. And this is what we are avoiding for any of you to have no definite knowledge of the step-by-step remedies or options available to a litigant. Given a particular situation, you should know that the case has already reached this point. Declaring a default when the case is already on pre-trial is something out of the blue, insensible, because the case will not go to pre-trial if there is no answer. See? Actually, the examiner will know from your own answer whether you understand the rules or not. No. After this remedy of filing a judgment or in a motion for judgment on the pleading, if this would not be available and the defendant's answer pleaded a permissive counterclaim, knowing that the permissive counterclaim is in the nature of a complaint filed by the defendant against the plaintiff is then called upon to file an answer to the permissive counterclaim. The answer must be filed within the same time frame for reacting to the defendant's moves. As far as the plaintiff is concerned, he is allowed 10 days after receipt of the defendant's answer to make his moves for summary judgment, judgment on the pleadings, or motion to declare the defendant in default. But insofar as answering the permissive counterclaim, the plaintiff has also the same right to answer the same within the period allowed the defendant for answering the plaintiff's complaint, because that is in the nature of a complaint where the defendant is the plaintiff. What plaintiff will file to join issue with the permissive counterclaim is not a reply, but an answer. So do not misunderstand this, that as far as the plaintiff is concerned, he files a reply, not an answer. If there was a permissive counterclaim raised by the defendant against the plaintiff should file not a reply but an answer. An answer is filed to join issue with a claim. A reply is filed to join issue with a defense. Since what will be responded to is a claim by the defendant, a reply is not proper. Therefore, it must be an answer. So all those matters which are available to the defendant in filing an answer are also available to the plaintiff in filing an answer to the permissive counterclaim. In one bar exam, the simple question asked in remedial law was, what does an answer allege? So now, from the rules on this responsive pleading of a defendant, you can gather an answer alleges the following. First, defenses against the plaintiff's complaint. This may either be a negative defense or an affirmative defense. The so-called negative defense are no more than specific denials. Denials made by the defendant of the plaintiff's material claim against him. Affirmative defenses are in the nature of confession and avoidance. The defendant admits the material allegations in the plaintiff's complaint, but raise new matters that would avoid liability for the plaintiff's claim as admitted by him. An affirmative defense always impliedly admits the allegations of the other party, but the pleader, by the nature of the defense raised by him, evades or avoids the claim made in the allegations. For example, if the action was for the recovery of a sum of money, the defendant alleged among his defenses that the sum of money claimed was already paid. Payment implies that there was an obligation which requires payment. So offhand, the defendant admits that there was such obligation. The burden of the evidence, therefore, shifts to him to adduce evidence showing that the allegations of the plaintiff that he owed him was already paid. Plaintiff is no longer required to adduce evidence that there is that obligation, because the nature of the affirmative defense is one of confession and avoidance. As far as the existence of the claim is concerned, this is already confessed. he tried to avoid this, then it's up for him to prove that there was indeed a valid avoidance. Where the defendant alleges prescription, impliedly it admits an obligation. See? Where the defendant raises usury, impliedly it would admit that there is a forbearance of money. See? There is interest. See? The allegations impliedly admits, at the same time tries to avoid liability out of the admission. Another matters raised in the answer are counterclaims. Under the rules, these have been classified as compulsory counterclaims and permissive counterclaims. Compulsory counterclaims are those arising from the same transaction or occurrence subject of the plaintiff's cause of action. Permissive counterclaim is a claim raised which did not arise out of the same transaction or occurrence subject of the plaintiff's complaint. It is entirely foreign to the plaintiff's cause of action. So you understand why this has to be answered. See now. Other matters alleged in the answer, the prayer or the relief, which is subject to the same principle applicable to the plaintiff's complaint. Then the signature of the counsel also giving rise to the same legal implications provided under Section 3 of Rule 7. Then the required verification, if at all required in law, and certificate of non-forum shopping if there was a permissive counterclaim. Also, if there would be more than one defendant, a cross-claim between the defendant may be possible. Where there are more than one defendant to answer the plaintiff's complaint, one defendant may be obligated to the other defendant in respect of the subject of the plaintiff's complaint. If the claim of one defendant against his co-defendant is foreign to the claim of the plaintiff, that is not proper for a cross-claim. A cross-claim is always compulsory in nature. It must always arise out of the transaction or occurrence subject of the plaintiff's complaint. That is why when plaintiff's complaint is dismissed, the cross-claim in the same action cannot stand alone. Cross-claim will inevitably be dismissed also. This is not true to counterclaims. counterclaim may stand even though the plaintiff's complaint has been dismissed, but not a cross-claim. Cross-claim cannot stand without the plaintiff's complaint because the cross-claim is rooted on the plaintiff's complaint. If that complaint has been dismissed, the cross-claim shall collapse. So, now, you understand this, you know what to write. So, I only hope you can follow. That is why in preparing for the bar, I have been advising reviewers not just to read and read. The more you read, the more you feel you do not know enough. See? You always feel that you are reading something new. Where in fact, what you are reading there is already trite, already obsolete. See? You read only those which are worthy of your time. Don't just read and read for the heck of reading. Some of you are even coloring what you are reading. That's bad. See? Because that will add tension to you. See? See? At this stage, what is necessary is for you to attain a pleasant handwriting and a civilized English language, not a language that is offensive. See? This shall be enough. See? Do not ever dream that you can become a lawyer when you have a handwriting that is offensive to the eyes. With the population of bar examiners now, examiners will never try to sacrifice deciphering what an examiner has read or has written. See? So you always improve the delivery of your reaction. See? Now, after these exchanges by the plaintiff and the defendant, let us finish the options available to the plaintiff. Now, the last option for the plaintiff is the filing of a reply. Under the rules, even though the plaintiff would not file a reply, all the new matters raised in the defendant's answer are deemed denied. So you may think that the filing of a reply is unnecessary. That is not accurate. Where the matters raised in the defendant's answer are new without any reference to the allegations to the plaintiff's complaint, the plaintiff is required to file a reply to join issue with the new matters raised by the defendant. Otherwise, during the trial, the plaintiff will not be allowed to adduce evidence on matters which he has not pleaded. More importantly, one, there is a matter raised in the defendant's answer which the rules require to be denied under oath, whether the plaintiff believes in it or not, the plaintiff must file a reply. If the defendant's answer raised an actionable document, which under the rules require a denial under oath of the genuineness and due execution of the document, any denial made not under oath will operate as an implied admission of the genuineness and due execution of the document. So to be able to place the denial under oath, a written pleading will have to be filed. That pleading is the reply. So it becomes obligatory to file a reply when matters raised in the defendant's answer have to be denied under oath, so that the oath may be properly reflected in the reply. After this, the case will go to pretrial. So, time for us to adjourn. Any aspect of what we have discussed which are not yet clear to you, you just write it down. Now you will observe what I am discussing with you is just the backbone of the procedure. Collateral to this, I shall discuss with you the incidents, like the required notice of hearing in motions, so-called dismissal of actions at the instance of the plaintiff, so-called interventions, so-called amendment, the legal consequence of subpoena. I want to separate them because these are not really part of the procedure. They are merely incidents made available by the rules for a litigant to facilitate his availment of the provisions of the rules. So let this not bother your review of the rules. So good night to all of you. May God bless you. Thank you. Thank you.